Today's video audio lecture is going to be concerning torts. Tort is a civil wrong that has been committed. It is a injury to another party caused by someone known as the tortfeasor. Generally speaking, you'll have a victim or an injured party that will bring a lawsuit, and the party that brings a lawsuit is known as the plaintiff, and they will sue someone known as the defendant or the tortfeasor. We've already discussed compensatory and punitive damages, which are the main type of damages we're going to discuss in this course. But basically, compensatory damages are damages designed to compensate a victim for the harm that has occurred, such as in a personal injury case, the property damage that may have occasioned as a result of the, say, an accident, as well as medical bills that may have been incurred, hospital bills, doctor bills, surgeons, therapy, therapists, as well as medicines, and also some items such as pain and suffering. The law suggests that everyone is free from pain and free from suffering prior to the injury, and that losing that ability to be free from pain is something that should be compensated to the victim, and so that's part of compensatory damages as well. Also, some items such as lost wages if they were required to be off work for a period of time as a result of the injury too. In addition to compensatory damages, there is an element of damages known as punitive damages. Punitive damages, punitive meaning to punish, are damages that are designed to punish a wrongdoer and to deter the wrongdoer and others like the wrongdoer from engaging in similar type of conduct in the future. Punitive damages are awarded only for intentional type torts, conduct that was not accidental in nature. It either has to be intentional or very reckless and callous type of behavior, such that you didn't care whether something occurred or not. An important note is that punitive damages are only awarded on top of and in addition to compensatory damages. So you generally won't find a lawsuit where a plaintiff will sue and be successful and recover punitive damages only. They'll also recover some form of compensatory damages to compensate them for the harm that has occurred. We're going to discuss three different types of torts. Your normal type, most common being the middle hyphenated bullet there, unintentional or negligence type of torts. Intentional type of torts, and then a third category known as strict liability. We're going to talk about some intentional type of torts first, and the first one we're going to discuss is known as assault. And notice that even though this PowerPoint slide refers to assault and battery, in truth, those are two separate torts. The assault is not a physical contact, but it is the placing of someone else in fear, in reasonable fear, of receiving harm, contact or harm, and the battery is the actual completion of the assault, or more commonly referred to as either a harmful or an offensive touching. And I'm going to explain that here in just a minute. Let's first go back to assault. For an assault to take place, you have to place someone in reasonable fear of receiving bodily harm. Example, let's say that someone is in your immediate vicinity and they pick up a baseball bat and threaten to bash your brains in with the baseball bat. That is an assault. It is an intentional tort in and of itself without anything more having occurred. The assault would be an intentional tort that gives rise to both compensatory damages and punitive damages. What about an attempted battery? An attempted battery is very common for an assault to take place. It actually is the very definition of a lot of assaults. You pick up a bow and arrow and you are shooting to kill someone with that bow and arrow, and you shoot and you narrowly miss that person. That is an attempted battery, but it's also known as an assault because it did reasonably place someone in fear of receiving great bodily harm. Battery, for the most part, the common types of battery are what you would normally think of, and a harmful type of touching. Someone beats you up, that is a battery. They hit you in the head with that baseball bat, that is a battery. A battery can also be what is known as an offensive touching. And an offensive touching, generally these type of torts occur during sexual harassment type of cases. You have a tortfeasor, a defendant, who has grabbed a woman's buttocks or breast, for example, against her will, without her consent, and it is offensive to her. In that case, a battery has occurred without anything harmful per se being accomplished. The offensive touching by itself is a battery. I will tell you later about, when we talk about employment law and sexual harassment, a case in which a client was kissed against her will. That was also a battery. What about some defenses to batteries? Well, consent, of course, is a defense. The kissing, the groping, etc., if it is with the consent of the victim, then they're not really a victim, and it's not a tort at all. What about a Golden Gloves boxing competition? Do you think that one person can sue the other person if they get beaten up in a boxing match? Of course not. They have consented to that physical contact as a result of the activity. And you can imagine some other situations in which consent could occur as well. Self-defense. Someone starts to attack you. Are you entitled to defend yourself? Of course you are. The law allows self-defense. It also allows the defense called defense of others, which is no more than self-defense if the party being attacked, for example, could utilize self-defense in order to protect themselves, then you can use that same defense to protect them as well. As long as the defense was good for them, it's also good for you if you are protecting them. The law allows you to use reasonable force to defend property. If someone attempts to snatch a cell phone off of your desk, for example, and take it from you, then you are entitled to use reasonable force to push them away, to take away their hand, etc., in order to protect your property. Are you entitled to use deadly force? Answer, no, not in the case of defense of property. The law will not allow you to use deadly force to protect your things. Will the law allow you to use deadly force to protect yourself or others? Absolutely. You have someone that breaks into your house. You are in reasonable fear of receiving great bodily harm or death, or one of your family members. Are you entitled to use reasonable force, including deadly force, to protect yourself and your family? Absolutely, you certainly can. Someone comes at you with a knife. If you have a gun, are you allowed to use that gun to protect yourself? Sure you are. The knife that the other person is threatening you with is a deadly weapon. You just have a better one than they do. And the law allows you to use your better deadly weapon than the one that they're using. Defense of property is an interesting defense, and there have been some cases where deadly force has been used in the defense of property improperly. And let me kind of go through a couple of those with you of some local examples. A few years ago, there was a case of a convenience store owner in North Birmingham who had been broken into several times over a short period of time, and he was fed up with it. He was irritated that his convenience store kept getting broken into, and he decided he would do something about it. And he rigged up what is known as a spring gun. And a spring gun is a contraption, in his case, that was tied to a gun, where when someone came in to the store by picking the lock or breaking down the door improperly, then the gun would go off and shoot them. And he set that so that it would go off after hours, after he had locked up the place and gone home. When that happened and it injured the other party, he got into a lot of trouble because, again, the law does not allow you to use deadly force to protect or defend property, only yourself. Someone has asked me before what would have happened if he had actually lived in the place. And if that's the case, it would have been a tougher, closer call. In that case, the law would look very carefully as to whether or not he was protecting himself and his family members, or whether he was protecting his things, the property itself. Another case, and this one was in Shelby County not too terribly long ago. You had a couple of robbers or burglars that were burglarizing a house and breaking in. And not only were the police called, but the homeowner and the homeowner's father was called, who lived fairly close. Well, the homeowner's father showed up with a gun, and he saw the people that were burglarizing the house, and they got in their car and started driving off. And he went down the road shooting at them as they were driving away from the premises. Technically, that is an improper defense. At that point, he's using deadly force in the defense of property, trying to retrieve property, if you will. And the law will not permit that as a defense. He would have gotten in a lot of trouble had there been any injuries that occurred as a result. And I'm going to go ahead and take a break here. I want to make sure that this is working accurately. I'm going to break this particular tort lecture into a couple of different parts. This is going to be the end of part number 1.